Ladies and gentlemen, thank you so much for taking your seats without having to make an announcement. It's always a first at the Ismaili Center. Welcome to the Ismaili Center today and for the talk, Dispute Resolution in a Digital Era. My name is Rahim Shamji, and I'm the CEO of ADR/ODR International, one of the organizing organizations for this event, but also a very proud member of the Ismaili community. So I have a double happiness of being here today with you. Welcome to our distinguished speakers, and to the live audience, and of course to all of you joining us in the room today. Just a few housekeeping announcements, if you could turn your phones to silent. And also we are not expecting any fire alarms today, so if you do hear one, please use any of the 4 exits to leave the social hall. I'm going to start quickly with welcoming the chairman of the Ismaili National Conciliation and Arbitration Board, Ali Khan Qasim, to welcome you here. Thank you.
Thank you, Rahim. Bismillahirrahmanirrahim. Master Victora McCloud, Amir Ali, Professor Ahmed, and Tony Guise, distinguished guests, ladies and gentlemen, good afternoon. My name is Ali Khan Qasim, and I am the chairman of the Ismaili National Conciliation and Arbitration Board for the United Kingdom. I would like to extend a very warm welcome to you to the Ismaili Center, London. This Ismaili Center is one of 6 in the world and was the first one to be opened in 1985 by the then Prime Minister, Margaret Thatcher. The Ismaili Centers are symbolic markers of the permanent presence and core values of the Ismaili community around the world. They incorporate spaces for social and cultural gatherings, intellectual engagement and reflection, as well as spiritual contemplation. They are also bridges of friendship and understanding, and importantly, serve to enhance relationships among faith communities, government, and civil society. We have been most fortunate to be guided by His Highness the Aga Khan over the past 66 years around the principles of dialogue, conciliation, mediation, and universal ethics to resolve differences and to embrace pluralism and diversity. The Global Centre for Pluralism in Canada, which was set up by His Highness and the Canadian government, epitomizes these values. The Ismaili Center echoes this, in that it is a space conceived in the spirit of peace and dialogue. May I take a moment now to share the work of the board of which I am chair. His Highness established the international, national, and regional conciliation and arbitration boards with the desire that they will serve as alternative resolution bodies for the community, be it for matrimonial, commercial, family, or any other dispute. The boards assist as long as one of the parties is from the community. The Conciliation and Arbitration Boards, or CABs, are founded on voluntary service and are comprised of professionals from diverse fields and a range of cultural backgrounds. The board is appointed by His Highness the Aga Khan, and upon appointment, all members of the board undertake mandatory training in mediation and conciliation, obtain accreditation, and also observe continuous professional development. Over the past 30 years, the CABs have grown in strength and numbers, and there are now CABs in 21 countries. As you can see, the community resides in several countries with different cultures and traditions and is truly pluralistic. The national CABs report to the International Conciliation and Arbitration Board, ICAB, which also organizes the training and oversees the monitoring and evaluation. This has ensured uniformity in our approach to mediation and its processes. More importantly, it has enabled mediation between two parties who may be residing in different jurisdictions. In such cases, an understanding of cultural values and embracing pluralism is vital. Further, it is imperative that the laws of the land and each of the countries are upheld during mediation. One of the unique features of NCAB is that it follows trends within the community and analyzes the root causes of disputes. These are then played back to relevant sister institutions who then put into place strategies to address them. For example, it was noted that one of the root causes of family disputes was intestate wills. The Aga Khan Economic Planning Board is therefore making the community aware through a series of workshops and presentations the importance of making a will and providing guidance on areas that should be considered when wills are drawn up. Dispute prevention is also an important part of our mandate, alongside dispute resolution. Another important feature is that the CABs carry out post-settlement follow-ups to ensure that agreements are complied with and wounds are healed. This, in turn, improves the quality of lives of the parties involved. Although the CAB system was established 30 years ago, the principle of ADR dates back centuries to the time of the revelation of the Holy Quran. Verses from the Quran make references to the importance of mediation and conciliation, and this has resonated over 1400 years through the time of Prophet Muhammad and throughout the Imamate. We are delighted that this very important and topical subject is being discussed here at the Ismaili Center. Mandatory mediation is growing globally, and it is becoming apparent that mediation, which is speedy, amicable, cost-effective, and confidential, is a better choice than litigation, which can be adversarial, drawn out, public, and costly. Many of the CAD members and other lawyers and legal professionals from the Ismaili community are present here today and look forward to hearing from the panel. I'd like to thank you, DEF and ADR ODR International, for allowing us to host this event here. And we look forward to being part of the dialogue and debate, not only today, but in the future. It is important that as we professionalize ADR and mediation in particular, that organizations like CAB play a vital role resolving disputes in communities. I'd like to wish the speakers well today and thank you all for coming here and also watching online. Thank you very much.
Thank you, Chairman Ali Khan. I now have the distinct pleasure in introducing our moderator, Amir Ali, sitting to my left. I haven't had the chance to ever do this, so we'll have some fun, shall we, Amir? Amir is a fellow of the Chartered Institute of Credit Management. Amir sits on both the CICM's think tank and technical committee. Amir also sits on law advisory boards of several universities and has 37 years of experience in both legal and enforcement sectors. Most importantly, Amir is the immediate past chairman of the Civil Court Users Association, the largest lobbying organization of its kind for civil lawyers, and the past president of the Institute of Paralegals. Amir was named in the New Year's Honours List in 2022 and was awarded an OBE by Her Majesty the Queen for services to court users and the law. Recently, Amir has been assisting Ministry of Justices, in plural, globally, wishing to transform their courts to incorporate online dispute resolution. Amir is a dear friend. He likes to have a lot of fun, and he's asked me to do something a little bit silly when he gets up in a moment. Amir, why don't you come to the stage? Thank you. You want me to take a picture of him talking to you?
I'll explain it in a second.
Right, let's do that.
No, we need to get the audience in.
I told you.
Ladies and gentlemen, thank you for that indulgence. There is method in my madness. My son, he's 30, He's not in law, which is good. Is also speaking in London today. And the idea was to give him some evidence that my audience is bigger than his. But of course, whoever wins that bet doesn't have to pay for dinner tonight. And I'm very conscious that I forgot my wallet at home, so he does need to pay. And if someone can actually take a screenshot of the numbers online, that'd be great. Because I really want to drill it down. Ladies and gentlemen, welcome. Dispute resolution in a digital era. Many thanks to both ADR, ODR International, affectionately known as AOI, and Disputes e-filing for arranging this event, and indeed the Ismaili Centre for the use of this exquisite space. It's actually my second time here this year. Decisions are made by people who turn up, and thank you very much to, my understanding is we have just over 100 in the room and several hundred online. So thank you all very much for making the time and trouble, taking the time and trouble to be with us and join us today. The first time this subject is being debated, I'm reliably informed. The conversation today will center around the key issues presented by the latest civil justice reforms. And our panelists, who I will introduce shortly, are three working at the heart of the civil justice system today. The ambition for today is really to cover a few talking points, and they include what sanctions and incentives the rules will look like going forward, the impact of pre-action protocols, pre-action reforms, and the extension of the fixed recoverable costs from the 1st of October, what the role of AI will play in resolving disputes, and the chances of any of that improving access to justice. So without further ado, let me introduce our panel. Master Victoria McCloud is a member of the CJC PAP Review Working Group. Master McCloud sits in the King's Bench Division of the High Court and formerly practiced at the bar. Recently appointed Secretary for the Judges Branch of the National GMB Union, Master McCloud is also a member of the European Law Institute's Digitalization of Civil Justice Systems in Europe Advisory Board. She is the nominated judge on the Judicial Conduct and Investigation Office panel. Vicky, I know, has been recognized in many times, but the most notable two that I've got down and that I know of recently was that Vicky was named in the Sunday Times as in the 50 Women of the Year 2020, was it? 2020? 2019, 2020, and is one of the 100 women 1919 to 2019 in the first 100 years archive. Welcome, Vicky. Professor Masood Ahmed is a member of the CJC PAP working group. Professor Ahmed read law at the University of Cambridge and completed his postgraduate diploma in legal practice at Cardiff University. After qualifying as a solicitor, he specialized in commercial litigation, and he was appointed Associate Professor of Law at the University in Leicester in 2017. Masood's primary research interests are civil procedure / civil justice systems and reform, alternative dispute resolution, alternative dispute resolution, and the interrelationship between ADR and the Civil Procedure Rules. As a member of the Civil Procedure Rules Committee, Professor Ahmed worked with members of the judiciary, policymakers, and leading practitioners implementing major civil reforms. He's currently assisting the Civil Justice Council in its review of the pre-action protocols. Welcome, Masood. Tony Guise. Now, what can I say about Tony Guise? Tony Guise is past president of the London Solicitors Litigation Association. In different capacities, Tony has been at the heart of every major civil justice reform of the past 30 years. Notable successes include the formation of the Civil Justice Council back in 1997, the campaign for the new court accommodation in 2007, which became the Rolls Building, and in 2013, cost budgeting, a reform which in 2023, this year, was unanimously supported by the CJC's Costs Working Group. A non-practicing solicitor, Tony now is a director at Disputes e-Filing, an online management platform. He now works full-time in and on the campaign to introduce effective IT in the civil courts. He writes extensively, but more notably, I've certainly seen articles in the Solicitors Journal, Mediate.com, and the AOI Journal. So I do encourage you to read some of those or register online for some of those journals. Welcome, Tony. So, ladies and gentlemen, I give you your panel. Now, before we start, and I am going to have some fun, I've just realized earlier this week that I've gone to dinner with 2 out of the 3 panelists, Victoria, Masood, but never Tony. And what I'm hoping for is to find a mediator good enough to try and settle that disagreement and get us over the line in terms of a dinner which Tony and I can go to, but more importantly, that Tony will pay for. So I am on the hunt for a mediator, and if anybody wants to come and say hello, please do so. Now, there's some hands going up, I see already. The one thing I have noticed in doing some of these in the last couple of years is that nobody wears ties anymore, and I don't know why that is. So what I will do with Rahim's indulgence is just if everybody can just put their hand up if they're wearing a tie today, that would help me. Must be around 10. If everybody wearing a tie comes and says hello and shakes my hand at refreshments, because I'm over 50 and I need to encourage people to come and talk to me, I will donate £10 for everybody wearing a tie to the Ismaili Centre today. But anyway, I just wanted to say that, and I think ties are just dying out and unnecessarily, and people should wear ties when they come to events like this, and certainly if they're on stage wanting to speak. The loose structure for today will be that each of our panelists will be given around 6 minutes. Those who haven't taken me out to dinner or are not wearing a tie may get cut short. In this order, Master McCloud first, followed by Masood, and bringing up the rear, Tony. We will then have a general discussion where I will pose a number of questions, hard questions like your favorite color, things of that nature. And we will then open it up to questions from the audience and, of course, those that are joining us on live. And I actually understand we're live streaming, is that right? So as long as you get my best side, That'll be great. So I hope that sounds like a loose plan. So let's dive in. I'll sit down for this now.
Well, thank you, everyone. First of all, thanks to the sponsors today for organising this, and thanks to my friend Amir for his kind introduction, and thanks, actually, above all else, to the Ismaili Centre for hosting us today. Looking around me, I see all this wonderful glass and all this geometry, and the beauty of geometry, the beauty of mathematics, and the sense of light that's coming in through these windows here. And it's a beautifully pluralistic space, and it's kind of a solidified metaphor, in a sense, for opportunities that we can have in life to openly discuss in fair ways and to reach opportunities to resolve conflict. And in that context, I was interested to hear about His Highness the Aga Khan's initiatives in relation to community dispute. And of course, the Ismaili tradition is one of pluralistic debate. So I'm very grateful to be here in this wonderful lit space today. I've got 6 minutes. That's the kind of judicial equivalent of speed dating, I suppose. So I hope to... I've passed 50 as well, so I have to encourage people to talk to me as well. I'm going to speak rather sort of ad lib. The context, my prime interest, and if you like, the subgroup that I was involved in dealing with the report on pre-action protocols and dispute resolution within those, was the digitization of the pre-action process, and it's something I feel very passionate about. We have a range of existing portals for pursuing litigation, but it is, and I think Masood has put it in this way before, it's a bit of a series of islands, different websites, different branding, different typefaces. They're all official, they're all governed by the rules, but it's perhaps a little bewildering if you're a member of the public to know which one to go to. We've got minor injuries claims portal, up to 5,000. We've got the general damages claims portal. We've got non-contentious probate portal. We've got the low-value injury claims portal up to 25,000. And that, in turn, is subdivided into employment liability, road traffic, and public liability. So these things are islands. Now, it may be thought that, and that suggests a need for simplification for a start, but it could be thought that talking about digitization might, if you like, be a sort of cynical or even just eminently practical way of addressing backlogs in the court system. Perhaps it might be said, well, aren't you just thinking of digitization really as a kind of second-class way of dealing with things to get them out of the system? I don't see it that way. Yes, it is the case that there are backlogs. And yes, it is the case that there is a need to move as many disputes as possible away from court to preserve resources. But I see the digitization of dispute resolution as actually more than that. Out of adversity, if you like, can come very positive things. And I think the digitization of dispute resolution processes affords our society the opportunity to do something quite unique and quite new in the light of developments in machine learning, the availability of mass data storage, the integration of systems, and the growth of algorithmic or other, even generative AI. And it seems to me that if we think about pre-action dispute resolution and technology in that positive sense, we can see a number of benefits that can flow, and which could be quite unique and a first, in my view. And when I speak, I speak only as an individual. I'm not speaking officially. I'm here simply in a, if you like, an academic or intellectual capacity in my own independent sort of way. Of course, a benefit is addressing a backlog. That's a public general benefit. But let's go beyond that. Let's consider what is possible if we digitize a system and if we engage in data collection as part of that. It offers the scope to produce systems which embody concepts of what the parties regard as just outcomes, not just what the law says is a legal outcome. At the moment, we don't have a handle. We don't know really what it is that people themselves regard as just outcomes and just processes. It isn't necessarily the same thing as winning. It isn't necessarily the same thing as having your day in court, although it's often thought to be. And it is not necessarily the same as getting a legally court-based remedy. The drivers of what people feel is a just outcome are largely unknown. That may seem strange after millennia of legal disputes, but perhaps that's driven by the idea that normative law embodies justice in itself, and therefore who are we to question that justice is anything other than simply adjudication. So if we design systems which gather data about settlement processes, about solutions that people are finding and how they reach those solutions in cases that don't go to court, if we use online systems to get that rich data and learn from it, we will have scope to understand what just outcomes are perceived to be. And that can improve the experienced justice for those in dispute situations, justice as between parties. But also it adds another limb, because as we learn from data collection, as we learn from what just outcomes actually are, that can feed into the system learning, so that benefits can be derived from my case and yours, my dispute and yours, how we resolved our differences. But that can inure for the benefit of others in the system. So it's a wider community benefit, because we will learn from how peace is achieved in settlements outside court, which at the moment is a closed box. So as I say, I think there are huge opportunities here for rich data collection about settlement processes, and also, of course, about what happens when parties don't settle. If we have an integrated system, as is effectively envisaged in the Civil Justice report, the first report, there will be a second one next year. If we have a system where a case flows from dispute resolution into the court if it doesn't settle, and certain steps have already then been taken and satisfied, we can actually trace the lifetime of a court case. So if the parties have sought to settle and haven't, we ought to be able to know how it ultimately all ends. If it goes to court, what's the outcome then? Or if it's going to go to court and they settle at the door of the court, what did they do? That kind of holistic integration of the lifetime of a court case can actually then enable us to feed into better pre-action dispute processes by having AI systems which can provide mediators with proactive suggestions for the parties, or can provide the parties with those suggestions directly, based on actual experience in other cases, and can give rise to prompts and suggestions about creative ways to solve disputes which don't necessarily involve court-ordered solutions, or solutions which could even in principle be ordered by courts. You can be much more creative out of court, in other words, but that creativity could be fed by the use of technology and the gathering of data. That, of course, means addressing in a new way notions of privacy. For the first time, one might be able to see the gathering of data as part of what would be without prejudice negotiations. So that's clearly got to be dealt with in a way which maintains anonymity and prevents harm being done by a loss of privacy. But the benefit to be gained if we can navigate that difficult space is, I suggest, potentially a huge one. Well, what about the potential downside? And we'll probably touch on this. If humans are involved in the mediative process, if humans are involved in dispute resolution prior to action, if that's going to be the effectively mandatory norm that you have to have a dispute resolution process, that does have resource implications in the sense that it needs human bodies, it needs mediators, it needs people who are trained in the necessary skills, perhaps in niche areas, perhaps as we saw in the introduction, in community dispute resolution, that's dependent on the nature of the dispute. And churches, mosques, other institutions actually play a very valuable role in that is often not seen and not acknowledged, but is a genuine one and has been for many hundreds of years. But it does mean that there's going to be a demand for many, many more people and a high degree of open access to those people to actually be involved in that system. And it's going to be a challenge, and it's going to be interesting to see how that's going to be addressed as to how we're actually going to deal with that if we're going to be implementing solutions which do involve human mediators, human pathfinders, if you like, in the world of a dispute. So, I mean, those are essentially the points I want to make. I'm just very grateful to be here. I know Professor Masood Ahmed is going to speak in slightly more detail about the report itself. We both work together on the committee. So I'll take no more of your time, and I'll hand over to Masood, if I may.
Thank you.
First of all, thank you so much for the invitation and to the Ismaili Center for this great venue and holding it here. Thank you also to Rahim Shamji and to Tony Guise for putting this together so quickly and so effectively, because the CJC PAP report just came out on the 23rd of August, and I think this is the first place where we're actually going to look at it in some detail and debate some of the issues coming out of it, because if the recommendations are taken on board, it's going to have a massive impact on the way disputes are managed at the pre-action stage, but also how the pre-action protocols in the pre-action stage fits into the wider civil justice system and the civil court process. So what I want to do today is to focus in on one of the major recommendations of the report, which was the proposal to introduce a new general pre-action protocol, which applies to disputes to which no other specific protocol applies. But before I go into the detail of that, I don't think we can have a discussion of pre-action protocols without referring to the great Lord Woolf, one of my heroes in civil procedure. He introduced the pre-action protocols back in the 1990s. And in his Access to Justice final report, chapter 10, paragraph 6, if you're interested, he said this: the pre-action protocols will set out codes of sensible practice which parties are expected to follow when faced with the prospect of litigation. And the emphasis was on party cooperation, early engagement between the parties to reduce the dispute and the issues in dispute, and to promote greater engagement with alternative dispute resolution procedures. The importance of the pre-action protocols were again emphasized by the Court of Appeal in the landmark decision of Jet 2 Holidays and Hughes in 2019. And in that case, at paragraph 6 of the judgment, the court said this: the pre-action protocols are now an integral and highly important part of the litigation architecture. And it was that decision which triggered this review of the pre-action protocols. Now, just getting back to the focus of my talk, so I'm going to look at the proposal to introduce a new pre-action protocol for disputes that don't fall within any other specific protocol. And this came about because when we carried out the empirical research before drafting the interim report, we sent out questionnaires to stakeholders, to the wider legal community. The responses were, in respect of introducing a new pre-action protocol, was, yes, we need a new one, because the current one, which is called the Practice Direction Pre-Action Conduct, was not effective enough. The wording wasn't tight enough, people weren't engaging with it, people are simply ignoring it, judges weren't really clear as to what the status of that was. So there was a clear majority from the respondents saying we do need this new, a new pre-action protocol for disputes which don't fall in within the specific protocols. So I want to briefly talk about three aspects of the new proposed general pre-action protocol. First of all, the guidance to the new pre-action protocol, which is set out at the beginning of this protocol, which can be found at Annex 2 of the final report. Then I want to talk about the general principles. What are the general principles, and how do those general principles, which are set out in the proposed general pre-action protocol, how do those principles relate to the specific protocols? And finally, I want to focus in on the three sequential procedural steps that must be taken by litigants under the new PAP. And those steps are, first of all, early exchange of information. Secondly, the need to engage with a dispute resolution process. And finally, the need for parties to produce something called a stocktake report. So let's quickly look at the guidance to the proposed general pre-action protocol. This is set out at the beginning, paragraph 1. And we made a number of changes, and we introduced a number of things at the beginning in order to explain what the pre-action protocols were actually about. What are the nature of the pre-action protocols, and what are we trying to achieve by getting parties to engage with that. And in clear, non-technical language, we try to explain that at the beginning of this new proposed General Pre-Action Protocol. And we say this at paragraph 1.2. The protocols are intended to encourage the early exchange of information between the parties and to provide a framework within which the parties can explore early resolution of the dispute without the need to start proceedings or narrow their dispute so that any proceedings can be resolved more quickly and at lower cost. So we're taking out the legal lease and trying to make it more engaging and understandable for people who aren't lawyers. The other major part of the guidance is consistent with the Wolf reforms, which is that the guidance states that the litigation should be a last resort. People should be engaging with one another openly and trying to resolve the dispute without coming to the court process. And party cooperation is at the heart of this part of the pre-action protocol. We also recommended mandatory compliance with the pre-action protocols, which was lacking before. So the empirical data that we got back from respondents was, yes, we like protocols, but what we find is the other party doesn't engage with the protocols, and they are not enforced by, or generally not enforced by the judiciary. So we need to make them compulsory, and there need to be effective sanctions which the courts can exercise. We also decided to make explicit reference to the overriding objective, which is the key rule within the civil procedure rules. And we integrated that within the protocol. And again, we emphasize the need for parties to further the overriding objective as well at the pre-action stage, as well as during the court process if the matter proceeds to court. Another important aspect of this guidance explains the relationship between the proposed new pre-action protocol and specific protocols. So what is the relationship between them? We wanted to avoid any sort of confusion developing amongst the judiciary or the legal profession and indeed litigants in persons. And we made this clear in the drafting. So we do two things here at paragraph 1.6 and 1.8. First of all, we say that this new protocol, this new general protocol, is the default pre-action protocols in the absence of a specific protocol. So if your matter doesn't fall within a specific protocol, like the PI protocol or clinical negligence or housing, then you should engage with this general pre-action protocol. And the second thing we do is we say that the general principles, which I talked about earlier on, which feature at the beginning of this new protocol, also apply to the specific protocols. So those principles are fairly general. But we make clear in the drafting that if the specific protocols have specific steps or additional steps that need to be taken, then those steps will apply. So the general protocol does not knock out any of the steps or procedures in the specific protocol, so they stay as they are. And then we also talk about the need to be honest in pre-action exchanges and the need to make sure that people are telling the truth, and we explain the seriousness of failing to do that. And this really reflects the decision in Jet 2 Holidays and Hughes in 2019, where the Court of Appeal confirmed that the High Court does have jurisdiction to commit for contempt of court in respect of false statements made under a pre-action protocol, even if proceedings are never issued. There are a couple of other things. I know time's running out, so I'm just going to jump to the last bit, which is what are so I'm not going to talk about this. So the general principles themselves are set out there. What I want to do is, just for the sake of time, sorry, let me just go back. I want to talk about the three sequential steps which we introduced. These three sequential steps the parties must take. We made them sequential because we said that if one of the parties fails to provide a letter of response to the claim, then the other party, the claimant, can then go ahead and issue proceedings, because clearly that would save time for that party. So making it sequential was very, very important. First of all, early exchange of information. Here we say that the parties are required to exchange key documents, and we explain in non-technical language what we mean by key documents, contracts, plans, and photographs. And this needs to be done at an early stage of the process. And then we introduce specific timeframes within which this needs to be done. So we're tightening up on compliance and making sure that the parties do this. And so what we say here is that there needs to be an acknowledgement of the letter of claim by the defendant within 21 days of receipt of the letter of claim. And then the defendant needs to acknowledge that and set out whether they are the correct defendant. If they are not the correct defendant, then and they know who the correct defendant is, they need to notify that to the claimant. After the acknowledgement stage, they have 90 days from receiving the letter of claim to serve a letter of response. So tightening up on the timeframes there. Now, the next bit is engagement with a dispute resolution procedure. Now, this is really important because we were trying to say, well, look, if you have an effective exchange of information, then that should foster better engagement with alternative dispute resolution procedures. And the purpose of this part, we said, is that the protocol is to ensure that, if possible, the parties reach a settlement before they incur the cost, time, and stress of litigation, against trying to use clear language to emphasize the benefits of engaging with dispute resolution procedures. And here we set out a number of dispute resolution procedures, including mediation, early neutral evaluation, ombudsman scheme, or even a without prejudice meeting. One of the interesting responses we got at the interim report stage was, well, hang on, what you're doing here is you're introducing mandatory mediation, you're introducing mandatory ADR, and therefore stopping parties going to the courts, which is their constitutional right. As we know, access to the courts is a fundamental constitutional principle. But we disagreed with that because in the light of the CJC report, which I encourage you to read if you haven't done so already, on mandatory ADR, published in 2021, that made clear that mandatory engagement, as long as there are various safeguards in place and they are proportionate, that is not going to undermine Article 6 of the European Convention on Human Rights, which deals with a fair trial. Clearly, if you are mandating settlement in that process, that would breach Article 6, but mandatory engagement wouldn't. And then we had a series of important decisions as well, which enhanced the requirement to engage with dispute resolution procedures. So we had the Lomax and Lomax case in 2019, where Lord Justice Molan said that pursuant to CPR 3.12M, don't worry too much about that, the court does have the power to order early neutral evaluation by a judge, even where one or more of the parties do not consent to it. And then we also have, obviously, the very important decision coming along in the Court of Appeal, Churchin and Merthyr Tydfil, which will deal with some of these issues. So we're saying, no, it's not going to breach Article 6 rights. And finally, the last procedural step after doing that is for the parties to sit down and draft a joint stocktake, meaning sit down and agree on the issues that you've agreed, set out the issues that you've agreed on, set out the issues you've disagreed on, and make clear from the claimant's perspective and the defendant's perspective why they can't agree on certain issues, and also setting out any key documents that have been disclosed during the pre-action stage, obviously not covering without prejudice correspondence, and setting out which are the documents they need. And this is all to sort of filter out all the benefits of engaging with the pre-action protocols so that it feeds into more efficient, proportionate case management, because the parties will then have to go to the courts. And just on this point, and I'll finish here, we've also drafted various templates to help the parties, and we've drafted a stocktake template. And a charity, a Support Through Court is a charity which assists litigants in person. They have offices in the Royal Courts of Justice. And we got their feedback on some of this, and they said that that these templates were straightforward and easy for LIPs to use. So we were very happy with that feedback. So I'll finish there. Clearly, I'll pick up any questions or comments that you have. Hopefully, we'll have an interesting discussion. later on, but thank you very much for listening.
Tony?
Well, ladies and gentlemen, I have some things to say you'll be relieved to hear, or perhaps not, but I can't begin without passing comment on our moderator's insightful explanation of my history. He's clearly been digging deep, but he reminded me that I've been at this now for almost 30 years, 28 years actually, 30 years, and it reminded me of a conversation that I had with a very senior judge quite recently, who was saying to me, "Oh, Tony, what are you worrying about? The first 30 years are the hardest," which made me think that perhaps the second are going to be the easiest. And I was encouraged in that view by the publication on the 21st of August, or 23rd, whenever it was, of the PAP final report, part 1. I was then discouraged on Wednesday evening when I was chatting with Richard Susskind, who was commenting about there being mountains to climb, Tony, mountains to climb, yet to come. But, ladies and gentlemen, my talk will spread good cheer and a sense of hopeful expectation for the imminent implementation of these reforms. But the context is this. The challenge is clear. England and Wales has the largest, if not the largest, amongst the largest backlogs of civil, family and tribunal cases in the world. The backlog is a cruel thing, causing delays throughout the system, corrupting and interrupting lives. 52 weeks before a small claims hearing can be heard, and that's mainly 48% of those are for claims worth less than £500. Regional variations are wide and extreme. 100 weeks for fast-track, multi-track in England, but 30 weeks in Wales. I'm grateful to Express Solicitors for the regional variations research. The waiting times are compounded by a system part digital and part paper. Compounded problems writ large by a crisis in judicial recruitment, particularly affecting district judges, who of course deal with most of these cases. Ladies and gentlemen, we are at the end of the first quarter of the 21st century, yet we are still talking today about the problems they were talking about in the 19th century. 200 years ago, the modern county court was mooted as a thing that should come into being, which it did, as you all know, in 1846. Now, the Civil Justice Council has set out the way forward, and we must work together to make this vision a reality. For what we do here may inform other jurisdictions overseas, as the Wolf reforms themselves have done, and enable other jurisdictions to improve on what we're doing. What is the opportunity? If we bust the backlog, we unlock time and money for millions of parties, not only this year, next year, but for untold years to come. During an engagement event with the Ministry of Justice, Sarah Rose, Deputy Director of Dispute Resolution, told me in March of this year that private sector mediators, private sector platforms would deliver the new pre-action phase. But so far, I've not seen any exploration of how many cases, how many mediators. Master McCloud touched on the issue, and she's right to do so. It's it is of central concern when planning. You'll be unsurprised to learn that DEF has investigated this issue, and we estimate there will be around 750,000 cases every year in the pre-action space for small claims, fast, intermediate, and multi-track. These super heavy volumes can only be handled online. Now, how many mediators? Well, a lot. It's not really a good working plan. But the good news is that ODR International, our co-host for this event, have been training mediators for years. And so we have the human resources to handle such large volumes. These are mediators regulated as required by the MOJ, and the scale of this means there are enormous business opportunities for mediators. Within the final report, as you'll know, the CJC listed in section 9 a long list of recommendations. And I just want to review those and explain how the concerns, which are rightly expressed by the Council, can be addressed. So the first one was to create a general pre-action portal limited to the main PAP steps linked to relevant existing online general claims portals. Well, I designed such a pre-action platform in October 2016. And I went further. I had it built and deployed in 2017. All pre-action portals, the Council say, should be designed to be used by professional court users and LIPS litigants in person, with layperson summaries to explain technical language where necessary. DEF will work with Law for Life Advice Now to develop our intuitive intake to deliver this Tier 1, this essential Tier 1 provision. The other recommendation is to connect the portals to professional users' case management systems via an API. Well, APIs, as we all know, long-established technology. I say to the law firms now, in this room and online, give us your APIs today and I will give you a solution for your clients that distinguishes your firms tomorrow. The other point they made, subject to the technology being available and cost-effective, Master McCloud referred to this as well. Developers of PAP portals should facilitate confidential dispute resolution discussions online through their portals. Absolutely. And that technology does exist. And DEF has been doing exactly that for the past 8 years. Now, some other providers may be trying to figure out how to do this, but AOI, DEF are ready. The other recommendation, although it doesn't appear in the, I don't believe it appears in the list in section 9, but it's important, so I'll highlight it here. The portal should be available in different languages. Absolutely. And so working with our partner, Teneo Translations, we can provide language options. And I'm not talking about English or Welsh, although we do those as well. But I am talking about the principal languages of a multicultural England and Wales. Teneo Translate websites for the likes of BMW. This is not nice to have. This is must have, and it is readily available. The CJC then draws, again, as I say rightly, issues about funding. How is this to be paid for? Costs, and the technical challenges. Well, DEF and AOI have developed a funding model that is considered to be sustainable and, critically, proportionate, especially for those smaller claims. Our platform has been running and in commercial use since 2015. Now, there were technical challenges, absolutely right. Those technical challenges have been overcome. The final point made, before I begin to wind up, you'll be pleased to hear, moderator, a formal certification process for private portals, court ready. This is the famous blue tick that Sir Geoffrey Voss speaks of in almost every speech. Well, I can tell you that DEF and AOI are court ready today. My final point really concerned timetable, something not addressed, again quite rightly, I think, by the Council. Well, the sooner the better, because the backlog only gets bigger every day. And some commentators, I was surprised to read earlier this week, suggest that it will be a considerable time, ladies and gentlemen, before these reforms are implemented. The CPRC is terribly busy. Civil justice reform is snail-like in its progress, which may be true. But I disagree. I look at the recent history of deploying pre-action portals of the kind that we are speaking about, and you will see, I'll share this with you now, you will see I have history, I believe, on my side. The claims portal, that's been mentioned already by previous speakers, took 18 months to build. The official injury claim portal was live within 2 years and 5 months of royal assent for the Enabling Act, Civil Liability Act, 2018. The Enabling Act for these pre-action reforms was given royal assent, as you know, on the 28th of April, 2022. I say we are looking at go live for the pre-action reforms in April or October 2025. Ladies and gentlemen, AOI and DEF are court ready. Are you? Thank you very much.
There you go. Okay. So I suppose let's start at the beginning. What role, I mean, this is the obvious question to me. And if it's a thick question, please tell me. What role will AI play resolving disputes? Now, I asked that question because recently the Master of the Rolls was asked the very same question. And his response, Sir Geoffrey's response at the time, was that it was too early to say. I just wondered what views the panel had on that. Would you like to expand on his thinking? Or if I can start with Victoria, I think.
Okay.
And then we'll work down the line.
Well,
And be as detailed as possible.
Of course, I couldn't possibly disagree with the Master of the Rolls.
No.
But of course, he was asked the question, what role will it play? I shall ask the question, what role could it play? Because what will it play, of course, depends on so many things beyond one's control. And, you know, there could be dismal failure, or there could be great success. What role could it play? Well, I think I highlighted it in my opening remarks, and that is that I have envisaged for some time, both actually for the judiciary in court and especially in pre-action mediative resolution processes, the creation of an informed AI system that is actually trained on outcomes data and process data and on rich information from settlement processes, such that sometime down the line, after training and validation and cross-checking with case outcomes over time and the system learning, we can actually have what I've always called a co-pilot. In other words, not a system that necessarily takes control and says, and acts as the mediator, but a co-pilot for a human mediator who can actually say to the parties, well, you know, most of the time, according to, you know, a system trained on millions of cases, parties tend to look at solutions in this sort of way. And most of the time, if they don't adopt those solutions, they end up with something worse at court. So it can develop a validated and evidence-based way to provide parties with that information and to guide settlements and sometimes prompt ideas as to creative settlements. In the long term, as I've also said in other fora, I don't rule out the possibility that some way down the line for certain sorts of specialist case, it ought to be open to parties to access AI systems which have been thoroughly trained and validated against case outcomes, to approach those systems online and without prejudice to anything at all, give it the dispute and see what it says it thinks the outcome probably would be based on similar cases, similar types in the future. They can take it or leave it. But it would be a great first step to enabling parties to say, well, at least let's start thinking along those lines. So I certainly see that it could have a very significant and very positive impact, driven, as I said, actually in a sense by adversity, in that this is addressing a backlog, it's addressing a problem, but it could be the seed that gives rise to the flower of something entirely new, and something that's driven not only by just reaching an outcome, but is driven by an understanding of what parties themselves report as being just outcomes, not necessarily just legal outcomes.
Tony? Oh,
Yes, yeah. I completely agree with what Victoria's just said. I mean, I think in terms of the positioning it within the pre-action stage, because that's where a lot of my interest is, I think AI has a massive role to play, potentially. And I think in terms of if the pre-action stage has been engaged with effectively by the parties, and if the parties have done some of these things that we're trying to promote, you know, open engagement, early exchange of information, engaging with dispute resolution procedures, I think AI can play a massive role in using that data at that stage to propose settlement options, something similar to what Victoria's just said.
Yeah.
But at the pre-action stage, I think it has massive potential to do that. And I think it reduces the cost as well, because one of the issues that came up with the review of the pre-action protocols was, well, you're making us do more at the pre-action stage. That means there's going to be more cost for the litigants. It's going to be more legal fees for lawyers who are advising at this stage. And there's a balancing act to be performed there. I don't want to go too much into that, but I think in terms of reducing that or dealing with those concerns from practitioners, I think AI can play a really useful role in proposing effective settlement options and solutions once the parties have gone through the process.
And have you given any thought on how you would engage with lawyers and this balancing act?
Well,
has any thought been given to that?
I think going forward, the key experience I've had is that you have to remain engaged with key stakeholders. You have to engage the profession. You have to engage, the advice sector. You have to engage the judiciary, and you need to obviously gather data and information from those parties in order to make the reforms more effective and for people to have confidence in those reforms. And I think in terms of AI, there needs to be that constant engagement and getting the views of people in order to understand how this would work in the future.
Tony mentioned meeting Richard Susskind a couple of nights ago in town. I was at the same event, and one of the things that came out of that to me was that AI is a scary subject. I just wonder how you, when you're balancing act and trying to take people with you along the way on the journey, how you do that.
I mean, ethical issues are always going to arise, and I think that's where the major sort of anxieties are from litigants and also from lawyers. Replacing humans with robots effectively and with machines who are not going to have that human interaction with clients. And there was an interesting study carried out in Tokyo University. It was an experiment in the law department, which Sir William Blair was telling me about. I went to a conference last week at Swansea University, and I was talking about digitalization of the civil justice system. He was talking about AI. And he was telling me that the students at Tokyo University took an AI system and they fed in various facts on a murder. And they told the machine to basically predict the outcome. And the outcome was guilty, guilty, guilty. But what they realized was that the AI system wasn't analyzing or picking up or dealing with the facts as humans necessarily would in terms of critical analysis of those facts, which actually could have a massive impact on the outcome. So yes, it was applying the law, but if the facts are defective, then clearly the law is nothing. I mean, you're sending away people when you shouldn't be. So that was an experiment, but you can see where the anxieties are and where some of the issues are and ethical issues are around that. I mean, in terms of civil matters, which I'm focused on, and commercial matters at the pre-action stage, again, as I said before, I think there's huge potential there, and I think the ethical issues, as opposed to family disputes and criminal disputes, are less.
Yeah,
and I think there's a bigger scope for application there.
Thank you. And Tony, do you have a view?
Well, I agree with everything that's been said by my
It's always good when the panel agree with each other.
I find it's best to be agreeable in terms of trying to make progress. Data, this must be the most exciting aspect of this whole project. I mean, digitizing onto platforms, as I say, that's been done. We've done that 8 years ago, over the last 8 years. But the data opportunity is massive. The question is how we garner that. On DEF's platform, our terms of use entitle us to gather pseudonymized data, and we provide a data stream. And I noticed from the final report, part 1, that there is reference in the recommendations, which I didn't touch on, to transparent sharing of data. I think there need to be conversations with the Ministry of Justice, who I know are online, about how that will be managed and how the cost of sharing that will be paid, because in order to garner that data, there has been a massive investment of time and money to develop the data gathering exercise. But in terms of the practicalities, I think it's very, very important when talking about civil justice reforms to address the practicalities. So the first thing, AI, whatever it is, algorithmic resolution needs is data. And what is not available at the moment through ADR, which has, rightly as a hallmark, confidentiality, is access to data. Chris Breeden, the mediator, posted on LinkedIn recently and reminded me that the excellent CEDA 10th audit report was based on 384 or something of that sort, 384 reports. But I haven't gone back to Chris on that yet, but the point is, some data is better than no data. And at the moment, that's probably the best we can do. But in the reformed system, we are looking at hundreds of thousands of cases that are a rich seam that can be used to inform, for the first time, empirical-based reform of the civil justice system. In other words, trying to convey in my brief opening remarks, enduring change. The challenge of the next 30 years is to bring about enduring change in the civil justice system. And data can do that.
Just if I may, chipping in, there's another layer, of course, to how algorithmic AI can actually help, and that's once you're out of dispute resolution, or if you're going to court, say, for example, actually it could also assist in saying, well, since this part of the case, or the whole case, is probably going to court, where should it go? Yes. At the moment, courts spend a lot of their time actually bouncing cases around, because someone will issue it because their solicitors are in Hull or whatever. Some district judge at some point look at it and say, well, no, the defendant is in Kingston on Thames. Or then the claimant might pipe up and say, well, no, hang on a minute, I can't travel, I'm somewhere else. And cases bounce around all over the country, sometimes also to the High Court, sometimes back. As things evolve, there's a risk that we will simply end up with a system where a computer looks at the address of the parties and picks somewhere. You could have a more refined system where the parties actually engage in answering questions and the AI has some appreciation of where witnesses are, where experts might be, which courts have lower waiting lists if you issue there, even if they're not the most physically local, so that you can offer a more intelligent way of channeling cases into the system and then also effectively pass on some of the data that's been built up as part of the compliance with the necessary pre-action steps. So you can get into the court system more seamlessly and actually save judicial time that way. But more than that, let's suppose that in the course of dispute resolution, it becomes sensible for the parties to agree to get a medical report of some sort. If we imagine that registered experts made available through APIs their availability data and their fee charging data and their expertise data, systems like that could say, well, Dr. So-and-so is available on these dates, which tally with when you're available, at this charge, and give them the details, so that you actually then can engage other professionals. It might be maybe a surveyor in a case where you need a surveyor to look at some building disrepair as part of a joint settlement process. They might want to go to some surveyor. They'll be given choice, but the system will actually know about, could, if it's done properly, know about the availability of those people in a sort of common marketplace. It's a resource that judges themselves don't have, and I've argued for some time that actually, as a judge acting like the kind of air traffic controller for litigation as well as trying it, wouldn't it be nice for me if I was making orders, hearing the parties, and we were selecting experts for cases, if I could actually say, Dr. So-and-so is actually at a 5-day trial in Hull, and he might be able to see you on the last day of that because he's going to be there physically. And the system could actually inform me. We don't have that information. And that would streamline things quite a lot. So there is a role for AI and algorithmic computation in that sort of practical sense and not just in the dispute resolution sense. And that has big resource implications in enabling more useful work to be done by courts.
I think I'd just, if I may,
Please.
Just add that I think, again, picking up on the practical, we have to start somewhere. and start somewhere soon. The backlog is too large, growing too large. And if we focus on developing AI models that become in need of, I know too much about testing and retesting and various beta and alpha and whatever versions, we shall never start at all. So I think we have to start with what is available in the market at the moment, platforms like DEF, there are others. The intuitive intake needs to be built. We're working on that. But introducing AI can't happen until we have the data. So the data must come first. We must then consider, with academics, you'll be pleased to hear, Masood, how that is to be used, how it is to be analysed. And then we can start developing, it seems to me, the AI.
Thank you all. Can I move on to something, Masood, you mentioned? You mentioned a particular case about Churchill versus Merthyr Tydfil. And I just wonder what you think. Do you think that the decision, I think this is going to be heard in November, early November sometime.
Yeah.
Do you think the decision will have any relevance to the reforms? Actually, I'd quite like to hear some more about that and your views on, in fact, everybody's views on
well,
that.
It'll have massive relevance depending on what the Court of Appeal says, because the Halsey case, which I didn't really touch on in my presentation, was running out of time.
No, but the idea was to ask the question so we could segue that.
Yeah,
now.
no worries. So in the Halsey case, as some of you probably are aware, Lord Justice Dyson said that compulsory ADR, forcing parties to engage with ADR, will undermine Article 6 rights under the European Convention on Human Rights. Please note that was obiter. But the problem with that statement was subsequent cases and subsequent decisions started to pull in two different directions. Some judges were saying, yes, it would undermine Article 6 rights, and other judges were saying, well, actually, parties should be going to ADR. We're not forcing them to settle in ADR, but they should be engaging with ADR. And there's two interesting cases that illustrate that divergent approach in 2017. So two Court of Appeal authorities. The first one was Thakkar and Patel. In that case, the matter gets to the Court of Appeal, and the Court of Appeal is deciding on the issue of whether the defendants should be penalized in cost because they refuse to engage with mediation. Court of Appeal says, yes, they should be. They should have engaged with mediation because of the need for proportionality, the need to further the overriding objective, to cooperate, etc., etc. So Lord Justice Jackson, and I think that was his last case before he retired, Lord Justice Jackson penalized the defendants in indemnity costs. And he went further. He said, hang on, although the defendants are saying we engaged with pre-action discussions and we engaged with without prejudice meeting, that's not enough. You've got to go one step further and have a structured ADR procedure like mediation. So Jackson is going even further than that. But then 4 months later, we had another case in the Court of Appeal, Gore and Naheed. 4 months later, Gore and Naheed, and Lord Justice Patton saying the opposite, saying we're not going to penalize the party who didn't engage with mediation because that party should be entitled to have the day in court. So you have this divergent approaches at the highest level, at the Court of Appeal level. And the jurisprudence is very sort of messy in that respect. And that gives a wrong impression to litigants and lawyers as to what their obligations are. But I think with the CJC report and with this decision coming up, this is a perfect opportunity for the Court of Appeal to get to grips with the jurisprudence and to give a clear message to litigants and lawyers that engagement with ADR is not going to undermine Article 6. But obviously we're not saying you must settle, because if you're saying you must settle also in that ADR procedure, that will undermine Article 6 because you're stopping the parties from coming back to the court. So I think it's a great opportunity for the Court of Appeal to put this issue to rest, and it's going to have a massive impact on future reforms.
Tony, do you want to add anything?
Yeah, I mean, I agree, obviously, with Professor Ali. The case is actually very narrow, so the Court of Appeal has, as we all know, the Court of Appeal has a choice. it can deal with what is before it, namely the application for a stay by the Appellant Borough Council, because it is said the claimant did not engage with the internal complaints process. And that really brings the Halsey point in. Will they get ambitious and say that, as they can do, that Halsey was obiter and that was a different division and we're not having any of that? Or will they simply say that this is the application for a stay and there's a stay and not go any further? Well, I think they will take full opportunity to make it clear, and I hope they do, to make it clear that ADR has to be complied with. But I hope they go and say the thing that is missing, from the final report, which I was quite pleased with, and Ahmed knows about this, I spoke with him before we came onto the podium stage, that the 28-day timetable, 28 days for complying with DR in the interim report, that's right, has, or it was 8 weeks, forgive me, 8 weeks, in the interim report has gone. And now we're left with a reasonable period. What is a reasonable period? Is it 3 months? Is it 6 months? Is it 12? Alex Christian from Winston Mediation is here, specialises in housing mediations. He well knows that disputes over mediation and the completion of resolution in pre-action, they can go on for 18 months. So is 18 months a reasonable time? And so I hope that issue, is it a lacuna? It's an issue which I hope the Court of Appeal take the opportunity to clarify.
Vicky, do you want to make a comment on that?
Since it's in the Court of Appeal and I'm a judge, I probably shouldn't comment on the case. I've been ordering, as has been reported, Hadley and Prisbelow, in budget cases where you may have £1 million budget. I've been saying, well, I'm not going to budget this until you have, and I am ordering you, to go away and engage in ADR using appropriately qualified cost professionals to narrow the issues between you and the budget. I've been ordering that. I think I've done it on 3 occasions. They haven't been appealed yet. And in Hadley and Prisbelow, all but one phase of a very large budget was actually compromised. And all that came back was a genuinely important point of principle that we could focus judicial resources on. So I've been getting away with it, but it'll be obviously interesting to see what the law really says. When
It's nice to hear you've been getting away with
yes,
it.
Yes, for years, nobody's noticed.
Vicky. Okay, go on.
And this case has attracted a lot of interest from all the stakeholders. You have the Bar Council, who are going to the Court of Appeal as interveners saying mandatory mediation is wrong. You've got the Civil Mediation Council and the Chartered Institute of Arbitrators and others on one side saying it's absolutely fine. And my question is the following, because we have students here and we've got many mediators here. And we always say that ADR is not alternative dispute resolution for lawyers, but it's an alarming drop in revenue. So Merthyr Tydfil, I suspect, will come back and say there's nothing wrong with mandatory mediation or ADR as long as it's not mandatory settlement. But we are still going to be faced with an industry and a profession that sees it as a massive threat to its livelihood. Your thoughts, please.
Thank you very much, Raheem. I agree with you in terms of where I think the decision will go. I think it's about engaging, again, as I said earlier on in one of my answers. I think there's a lot of, there would be a lot of anxiety amongst lawyers because of the revenue issue. But there are lots of opportunities, I think, for lawyers to get involved and to engage and to understand where those opportunities are. So it's not necessarily taking them out of the picture, it's actually trying to bring them along the journey as well. And there are lots of opportunities, both pre-action, during the court process, and it's worked really well in other jurisdictions though. Canada, for example, works very effectively. They've got a stronger mandatory mediation approach. It's in a statute in some of the provinces. Yeah. Australia, China, for example. So there are places where it's working very effectively, but it's about staying engaged with the profession, and it's about it's about collecting data and getting feedback, essentially, and taking people along the journey as well. So I think there's a lot of anxieties which are probably misplaced, but there are lots of examples around the world where it's working very, very effectively.
I mean, I think one could say ADR is additional directions of revenue, in the sense that, I mean, if you think about the printing presses, you know, when we had hot metal typesetting and it became computationally done instead, I mean, we're going to need thousands of mediators. We're going to need real expertise in dispute resolution. It's a big, huge opportunity. I'm sort of not surprised the Bar Council would be opposing the case, given that there's less pleading and fewer court cases. Well, there you go.
I never disagree with Rahim about anything. My name is Mark Reynolds. I was chair of the bar last year. I don't know what the intervention this year is saying about it precisely, but my strong suspicion is much of it is motivated because they don't yet have an alternative system coming out of the Ministry of Justice to create the sort of mediation structures that would actually make a difference. And so what probably is going on is not the profession being afraid, because it isn't. And I think, if I may say so, some of the cynicism from the platform is unmerited. But actually what we want is not the Ministry of Justice to say this is an excuse for not sorting out the resources in the court system. Because if you actually had the judiciary in place and the digital filing in place and the structures in place that would permit backlogs to be dealt with properly, then having an element of mediation to facilitate dispute resolution is not going to hurt anybody. So I would just be cautious about assuming that the profession is defensive in that way. I'll give the microphone back to Rahim.
In fact, at that point, are there any other questions from the audience? We have a hand here.
I'm a litigation lawyer, so I would fall in the category of people who might be concerned, maybe, about how this will work in practice. So, you know, I think in practical terms, it was discussed that there would be the key documents exchange, there would be a production of a stock take report. We have seen similar ideas in the disclosure pre-action protocols and the systems that are now followed for disclosure in litigation, but we've also seen that cause a number of hurdles, a number of delays, and just increasing costs for all parties involved, because it's very difficult to agree a joint disclosure review document, for example. And so just wondering how much thought has been given to the practicalities for large, high-value disputes, where some of these matters, you know, it creates an extra hurdle, which may not be the most effective way of dealing with those practical matters. And then a second question, that in this context, and given our community context, there are, as we've seen from the address from Chairman Ali Khan, about non-formal mediation available in various faith communities, and what do the panel think about the interplay? Because if mediation is becoming mandatory through the courts, will there be any consideration given to mediation that might have taken place before the dispute reached the court? And will credit be given to the parties who might have invested in those processes before they got there? I'm not just asking that as a Ismaili Muslim, but you know, there are parallel procedures in various faith communities.
Who wants to jump in?
Well, I just wanted to, on the question of high value, of course, part two, the representations of my former association, the London Solicitors Litigation Association, maybe a member, they were concerned about how this would work in high value. I think if I read part one rightly, the CJC working group was somewhat sceptical of the LSLA's submissions. But nevertheless, it's been given to a working party, as you may know, of LSLA, Chancery Bar Association. I think ComBar is also involved to come up with something. And as part two is supposed to be about sector-specific litigation. I think it's only the ComLit that's actually going to be. And I acknowledge the success of my association for securing a part two. But that's what I wanted to say about that point. So
I think on the community aspect, I mean, the obligation will be to engage in dispute resolution, doesn't necessarily have to be a particular licensed form or anything of that sort. So I'd be very surprised if parties had approached even just creating a system of their own, finding a respected person that they both trust to do it, or whether through their church or a community group. I would be very surprised if that didn't count. Rather the opposite, in the sense that it's an ideal harnessing of society's expertise in solving practical local problems with local knowledge. So yeah, I would have thought, I don't know if Masood's got a view on the wording of the report on that, but I would have thought it would be perfectly acceptable.
Yeah, what I do want to do is just
Yeah.
I mean, Tony's answered the question about complex litigation. We're fully aware of that, we're conscious of that, we're engaging with all the necessary organizations, including the Bar Council and the Chancery Bar Association and the Commercial Bar Association. And we had very useful comments and helpful comments from the senior judiciary doing commercial work. So we understand that and the risk of front-loading costs by a huge amount. So we are looking at that, and there's most likely going to be a slimmed-down version of what I was discussing earlier on. But please note in the proposed general pre-action protocol, we're not setting a disclosure standard. We did have a discussion around this, and there was a detailed analysis of what we're asking people to do. But it's less of that. It's sort of just produce the documents which are important to the dispute. I mean, if it's a contract, if it's a photograph, it's a map. So we're not trying to implement the disclosure standard under the civil procedure rules at that stage. So we've moved away from that. But as I said before, a different approach for high-value complex cases.
Thank you. Can I ask whether there are any questions from the online audience that we have? They've not come through. Well, we could debate this all afternoon, and time is running short. I'll ask one final question, if that is allowed. And in a nutshell, and this is to all of you separately, in a nutshell, what do you think about tech and dispute resolution, and what's your blue sky thinking on the subject? Just to end on, can I start with you?
Yes,
Tony?
Yes, of course. Well, I love tech. I'm an IT entrepreneur. Why wouldn't I love tech?
In a nutshell.
Yeah, and that's my nutshell. But I think in terms of, we need to be looking not where we are now. We need to be getting on with now. As I said, simple start, but we need to be planning for the future, incorporating AI.
Thank you.
Massive potential, obviously. Lots of jurisdictions way ahead of us, including China with their internet courts and the online courts, where I think it's going to be extremely important that we continue to gather data, as Vicky was saying earlier on. And my real concern there is to make sure that those engaging with these procedures and processes understand them. They understand the outcomes, understand the procedures, and really what I'm talking about is procedural justice, making sure that people engage, but they also understand what's happening with the system. But yeah, lots of potential, but we need to make sure that there are safeguards in place.
And the very last word from the only judge in the room.
Well, one of the things I was going to say is don't just let big judges make decisions about tech. They're the last people really ought to be. Of course, we should be involved, but we need a pluralistic marketplace where people who know what they're doing in the tech field are actually involved, where specifications are open, where there's an open source sort of culture, and where different implementations can be done in ways which simply conform with standards. So we mustn't have monolithic tech contracts or anything of that sort. These things have a habit of not working well. But also, I think, don't make it yet another judge-led initiative. It should be led by the people in the industry, as well as the judiciary and the practitioners.
On that note, can I ask everyone to thank our panel?
Thank you very much, Amir. Thank you very much, Vicky, Masood, and Tony. I thought just to pick up on that question that Alia asked about faith communities and other communities doing mediation. In family, you cannot go without a MIAM certificate. And that's already being mooted in light of your report, that the civil should be in the same situation. And I think this is a genuine concern, if not a fear, but a concern from many people who practice in the community and other alternative areas. But I take hope that you both feel that others will be open to this. Ladies and gentlemen, that was fascinating for those of us who have a real interest in this area of expertise, but also the opportunities that are going to come by. And I will say one further thing that I've felt from the three speakers, which is that this PAP report and what you're saying is for once, for me, an opportunity to look at the users rather than the people that help us navigate the system. And the other night, the event that both Amir and Tony talked about were the three Suskins, as they call themselves, Richard, Daniel, and Jamie. And if you haven't heard of them, you should. Were being interviewed by Emily Maitlis at an event called AI and the Future of Humanity, which we both, all three of us, attended. And one of the things that Richard Susskind, who's one of these brilliant futurologists, said, which I think we should all think about, is let's not focus on process. Let's think about what people ultimately want. And they want the problem to go away. And if that's what we want to happen, then these systems hopefully allow them to engage in a process, procedurally just, but ultimately it should go away and not last a long time. But thank you so much for your enlightening thoughts. Thank you to all of you for attending. Thank you to the online crowd who over 100 people have joined us online. So thank you so much for your time. So a big round of applause for them.